When I checked my mail on October 3rd, 2022, I received an unpleasant surprise. There was an envelope with no return address mailed from Capital District 208. It had a stamp with some flowers on it, with a printed postmark on top that said in cursive script, "Thinking of you," and above that, "Mail a smile." It was from Joe Johnson. In it, I found a printed motion for Rule 11 sanctions and pre-filing injunction. Johnson was telling me that he was planning to ask Judge Chuang to impose sanctions against me for trying to remove my own company's case to federal court as I had scrambled to find an attorney. The motion was poorly worded and repetitive, but my favorite part was the rationale at the end that Johnson used for invoking the dreaded Rule 11 at all. He quoted a case from the Fifth Circuit from 1986 to argue that I was, quote, clogging the judiciary with meritless litigation. Never mind that he was the one who filed the litigation in the first place, because I had the audacity to publish a few public records that he had voluntarily put his name and email address on. It was just another headache on top of a headache. Paul didn't seem too worried, fortunately. As he pointed out, Johnson wasn't an attorney, so he couldn't be awarded fees for his time. It was another one of the baked-in injustices against pro se litigants that happened to work in my favor in this instance. I was counting the days until October 20th when the hearing was scheduled. It was going to be held telephonically, so fortunately there was no need for anyone to actually go anywhere. Aside from the Rule 11 headache, there was one other problem, which at first seemed minor and then began to grow in scale at an exponential pace. Johnson, who had already learned was a judicial hacker of the First Order, had figured out how to exploit a hole in the federal rules of civil procedure. It wasn't the sort of hacking that required a computer. All Johnson needed was a pen, paper, and another flowery postage stamp, and that was enough to cause total mayhem. From Think Press and PlainSite, this is Broken, a podcast about what we like to call the rule of law and how in the United States there isn't one. We'll talk about all aspects of the legal system through the lens of PlainSite, a legal and financial research platform where you can find information about things like lawsuits, lawyers, companies, and judges. On PlainSite, anyone can read anything the government produces for free with no account. It really does put the world's complexity in plain sight. The Johnson case was making me wonder where the limits of complexity actually were in our society. Based on the IRS's tax forms, for example, the answer could be that there were none, that it was boundless. America's legal system was and is based on the idea that having procedures in place is what makes for just outcomes. In this system, equality is basically defined as everyone following the rules. But what if those rules and procedures are so intricate and Byzantine that it's only possible for the wealthiest elites to pay people to spend their days learning and following all of them? That's one problem. The other problem is what if those procedures are so ridiculously convoluted that the judges who are supposed to enforce them can't even keep track themselves? Well, I'll tell you what happens. You end up with a broken system. In preparation for the hearing, I wanted to know everything about Johnson I possibly could. Paul's homework assignment, indexing all of the legal claims Johnson had filed in his prior litigation, had yielded quite a list. I'd put together an Excel spreadsheet with one case in each row and the different claims in the subsequent columns. If a bunch of cases involved the same type of claim, it made it easy to see. I ended up needing 45 columns from G to AY in Excel to list all of the different claims I found, and this was just in about 25 of Johnson's cases. He was fond of suing for misrepresentation, fraud and deceit, negligence, intentional infliction of emotional distress, invasion of privacy for intrusion upon seclusion, breach of contract, unfair or deceptive trade practices, tortious interference, which is when you mess up someone else's contract, defamation, libel, violations of the Maryland Consumer Credit Reporting Agencies Act. The list went on and on. There were even some one-off claims for accounting, reformation, and specific performance. I got the sense that Johnson did some of this for fun, kind of as a creative outlet. He certainly was creative in his approach to litigation. And either the world was more unfair to Joe Johnson than any person alive, or it was mostly just nonsense. Every one of the cases I researched gave me the distinct impression that it was all the latter. In Johnson versus BMW of North America, I learned that the man suing my company over the publication of his lawsuit about a lawsuit drove a 2015 BMW 435i xDrive Grand Coupe, which he was unhappy with. And why was his BMW unsatisfactory? Because, in his words, quote, "The vehicle is manufactured and equipped with 10 years of factory connected drive safety features such as e-call, teleservice, and remote services, until April 15, 2025, which he was told, quote, also included convenience features in the vehicle such as BMW Online, widgets, weather, third-party apps as Pandora, Spotify, and others, and advanced real-time traffic information. The catch, according to Johnson, was that, quote, defendants, its agents, servants, and employees knew that the vehicle was equipped with the 3G wireless technology, and that once that technology is sunset and became obsolete, that it could not be retrofitted or upgraded to the latest technology, and that none of the connected drive safety features, including the convenience features that were included with the vehicle, would be available in the vehicle any longer. Defendants withheld these pertinent facts about the vehicle. So, Johnson sued BMW because the telephone companies decided that 3G was obsolete in the used car he bought. Like I said, creative. Then there was Johnson versus Exactus LLC, where Johnson sued a marketing firm for exposing his data, along with 340 million other individuals, in a 2018 data breach. This case had caught my attention early on because I thought the attorney, Matthew Skipper, might be willing to talk. But it also scared me because it was one of many cases where Johnson exploited a unique aspect of the Maryland rules of civil procedure that had no counterpart in the federal rules: the motion for immediate sanctions. Maryland Rule 2-432A provides for immediate sanctions for certain failures of discovery. So Johnson would file a lawsuit, maybe conveniently forget to inform the other side that he had filed it, and tell the court that he had served discovery right off the bat. When the other side failed to respond, he would file a motion for immediate sanctions. And then he could automatically win the case and a cash judgment then and there. The court never seemed to bother to check about whether or not he was telling the truth when it came to service of process. After initially failing to respond and ending up in default, Exactus eventually regained its footing and ended up settling the case. For how much or on what terms? I had no idea because, as usual, Maryland wouldn't let me see any of the documents. Beyond Johnson's wild history, I had a lot to discuss with my lawyers. First, there was the matter of strategy. Was it best to file a motion to dismiss, or to try to transfer the case to California, where it should have been filed in the first place? Typically, lawsuits are supposed to be filed where the defendant is, not where the plaintiff is, and as I may have mentioned, Think was definitely not in Maryland. In California, Think would have had the ability to take advantage of the California anti-SLAPP statute, a law designed to protect free speech and do away with cases exactly like this one, which threatened it: strategic lawsuits against public participation, or SLAPPs. Congress never passed a federal anti-SLAPP law, so it was up to the states to pass their own, and California had and still has the strongest one by far. Under the California anti-SLAPP law, losing what is called a special motion to strike under California Code of Civil Procedure section 425.16 means that the loser is required to pay the winner's legal fees. The fee-shifting clause, as it's called, is mandatory, and it's intended to dissuade frivolous litigation. In order to qualify as a SLAPP, a lawsuit goes through a two-step analysis by a judge within 60 days of filing to figure out if it's connected to a so-called issue of public interest, and if so, if it looks like the claims have any merit. Because they are filed in the courts, most lawsuits themselves are considered petitioning activities protected by the First Amendment that are matters of public interest. In California, Johnson's case, which was seeking to stifle Think's First Amendment-protected freedom of speech in republishing court records, wouldn't have stood a chance. Maryland also had an anti-SLAPP law, but it's widely considered to be weak. That's because there's no mandatory fee-shifting clause. In fact, the Maryland anti-SLAPP law doesn't require judges to do anything at all, except hold a hearing at some point, which would probably happen anyway, since you don't really file an anti-SLAPP motion without also filing a motion to dismiss. Paul, in his role at Public Citizen, had actually lobbied the Maryland legislature about fixing its law years before. So I was at least comfortable that I had lawyers who understood the relevant legal landscape as well as anyone might. Also on the agenda was what to do about Johnson's two outstanding motions: his outstanding motion to strike the notice of removal I'd put in the mail when it seemed like no lawyers were responding, which was now old news since it had been amended by a later notice with a lawyer's signature, and his threatened Rule 11 motion. The Rule 11 motion wasn't actually on file with the court yet because Rule 11 requires a 21-day grace period to allow the other side to fix the problems being alleged. In our view, we had already done that, and there was no harm to Johnson. But the real news was that Joe Johnson had decided to amend his complaint. Not once, but twice. When a party amends a complaint, it means that the old one effectively disappears, like it was never filed, and it's replaced by the amended version. The amended one can have new facts, new defendants, and even new claims. This can happen as many times as there are amendments. Fortunately, the Federal Rules of Civil Procedure place some reasonable limits on the amendment process. Rule 15 is entitled Amended and Supplemental Pleadings, and Rule 15A1 gives the plaintiff a freebie. You can amend once within 21 days after service, or 21 days after the defendant responds, basically whichever is later. After that, you need a judge's permission or the permission of the other side. This prevents abuse of the privilege since in theory, a case could just go on forever if the plaintiff kept amending their complaint every day with new information. Amended complaints are numbered, first, second, third, etc. It's not unusual in some cases to get up to a third or fourth amended complaint before things really move forward. When Johnson filed his first amended complaint, though, it didn't show up in federal court. That's because he never sent it there. Perhaps because it crossed in the mail with the first notice of removal, he only sent his first amended complaint to the state court in Prince George's County, which docketed it on September 26, 2022. One of the many frustrations I have with the Maryland courts is that the descriptions of filings on the docket are not always easy to follow. In federal court, as much as everyone hates PACER, they're actually much clearer. Here's what the clerks typed in for Johnson's first amended complaint in state court. Quote, amended complaint, capital F, lowercase d, period 007, first amended complaint and jury demand, FD, period KSS, space E 10/4/22. Period. They can get cryptic with lots of abbreviations, tons of misspellings, and virtually no consistency between types of documents. Sometimes the lawyers or the parties write the descriptions. Sometimes the clerks change them. Sometimes they don't. The next entry, or the next line in Maryland parlance, also dated September 26, 2022, said Notice of Removal to U.S. District Court. This was the notice of removal that Oliver had sent by snail mail, telling the state court that it no longer had jurisdiction over the case. This presented an interesting question because if the notice had been docketed earlier on the 26th, it would have blocked the first amended complaint from even being considered. Or so I thought, because the entry after that, dated September 27, 2022, was also categorized as an amended complaint, but the clerks had written that it was the second amended complaint. We hadn't even seen it. What is going on here, I thought. It wasn't easy to tell because unlike PACER, which makes use of this invention we have called Arabic numerals, there are numbers associated with almost every docket entry on PACER except minor asides by judges that don't require a piece of paper. Maryland's courts had not yet learned of the concept of numbers. In Maryland, every document is, according to the database, just an abstract idea represented in a timeline which can involve hundreds or thousands of documents. So if you want to refer to a specific document, you can't just do what you would do in federal court and say, oh, look at electronic case file or ECF number 17. Instead, you have to say, the document filed on September 27, 2022, but not that one, the other one, the one entitled motion for whatever. It's madness. And this madness is the fault of the database engineers who designed the court's case management systems, who never thought about maybe using numbers. There's another implication that follows from Maryland's refusal to acknowledge the concept of numbers. Unlike in federal court, where there are stringent cultural norms against messing with the docket, Maryland clerks do it all the time. Things disappear, get edited, get rejected for vague or incorrect reasons, and generally change. When there are numbered documents, you can see if there's suddenly a gap between documents 17 and 19 because document 18 has magically disappeared. But if there are no numbers, someone looking at the docket for the first time would never know. Also, remember that description I read for the first amended complaint? If you're listening closely, you'll note that I said capital F, lowercase d, period 007. Well, guess what? Even though the Maryland judiciary doesn't think numbers are important, the individual clerks do. So they will sometimes, but not always, give documents numbers themselves, which they just shove arbitrarily in the description. So for the first amended complaint, that was unofficially document 7. In the description for the notice of removal, there was a reference, though with lowercase letters and no dot, to FD008. The second amended complaint was capital F, lowercase d, period 009. and the second notice of removal was lowercase f, lowercase d, 010. After that, the clerks forgot to number any more documents. Now, if you think I'm crazy for harping on this stuff, I get it. It's nuts, completely. Who cares? Who would even notice? But just wait. That second amended complaint, unofficially document 010, should never have been docketed at all. Unofficial document 009 was the notice of removal. That should have been it, the end, nothing further, case closed. But there was a second reason it made no sense. Johnson hadn't gotten the court's permission or ours to amend again. So I looked up the Maryland rules on amendment and my jaw hit the floor. It was different than Federal Rule of Civil Procedure 15. Maryland let a plaintiff, such as Johnson, amend as much as they wanted to, so long as it was within a time frame on the case's scheduling order. He didn't need permission. This was bonkers. We were already in federal court where you did need permission to file a second amended complaint, and he hadn't gotten it. But even if the second amended complaint was technically allowed under the Maryland rules, you still can't have a case pending in two courts at once on two different paths. It doesn't make any sense. But here, the clerk had allowed this second amended complaint to be docketed even after the court knew that it no longer had jurisdiction. Only after the second notice of removal was docketed, the one for the amended notice that the lawyers signed, did the Maryland state clerks bother noting, case disposition removed. That meant that they had changed the case status flag in their database and that the case was no longer open. I had found the clerks in Maryland aggravating before when they wouldn't let me see my own company's case records, but this was a whole different level of incompetence. Now we had a new problem, and it was a big one, because there were 3 versions of the complaint on file in various places. The initial one I received on September 6, 2022, this first amended complaint that just squeaked into the state court record before the first notice of removal, and the second amended complaint that didn't belong on the docket in state court at all. Which complaint was active? It was not at all clear which one Judge Chuang would think was the correct one to work from. To make matters worse, the first amended complaint and the first removal notice had come in on the same day, making their order on the docket completely arbitrary. Which complaint was active actually mattered. In the original complaint, Johnson asked for $25,000. Not enough money to clear the threshold for federal diversity jurisdiction without doing some arithmetic. But in the first amended complaint, he added new claims and upped his demand to $75,000, which was the exact amount necessary for the case to proceed in federal court under federal law. What I mean when I say that is that 28 U.S.C. section 1332a, which is a federal statute, specifically says, "The district court shall have original jurisdiction of all civil actions where the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and costs." So the number 75,000 is actually hard-coded into the law, inflation be damned. If you want to sue in federal court in a situation where every party is in a different state, the dispute has to be worth $75,000 according to the plaintiff. The First Amendment complaint just cleared the hurdle. What the defendant thinks the case is worth doesn't have any bearing on the issue. In Johnson's Second Amended complaint, he made exactly one change, dropping the demand down from $75,000 to $70,000, just shy of the threshold, a deliberate ploy to evade federal jurisdiction while still maximizing what he hoped to win. He clearly knew what he was doing, and he realized he'd made a mistake. In fact, Johnson was something of an expert on the federal removal process. I found several cases where he had successfully defeated his opponents, corporations who were desperate to get to federal court and stay there, just as I was. Sometimes, not all of the defendants stated that they agreed to removal, which is a requirement. Other times, Johnson argued that the defendants didn't meet the strict 30-day deadline, also a requirement. And, as critical as some of the federal judges were toward Johnson, and some were pretty close to scathing, their hands were tied. The laws were strict. They had to admit he was right. The other main difference between the initial complaint and the first and second amended complaints, apart from how much money Johnson wanted, was what he alleged in the claims. Everything except the paragraph numbers was pretty much the same through count 5. The initial complaint for some reason skipped over paragraph 4. But then the first and second amendment complaints added new claims for defamation, libel, which is just written defamation, retaliation, violation of Maryland commercial law, and injunction, which isn't a claim at all. Johnson was now alleging that something I had done in the process of researching him after he filed the lawsuit was illegal. I hadn't even thought about it when it happened. I had tagged his PlainSite profile as a vexatious litigant. Everyone could see it, including Joe Johnson. When I explained this to Paul, he was not happy, but he seemed to get over it pretty fast. After all, it was obvious that Johnson was vexatious. He'd filed more than 100 lawsuits, almost none of which he'd won. But now Johnson was alleging that one simple tag, vexatious litigant, was defamatory, a statement made with, quote, reckless disregard for the truth. It was totally absurd, a self-proving allegation, and true statements cannot be defamatory. Also, he was suing as Joe Johnson, but the profile on PlainSite was in the name of Joseph R. Johnson, Jr. Who would even know that that referred to the same person? He also alleged that I had sent emails to, quote, third parties, calling him a vexatious litigant. This was true. I scratched my head at this one, though, because how did he know? Did someone from the court forward him my email? That would be interesting. Johnson was now alleging that this had caused him to sustain damages, including, quote, damages to his reputation, loss of sleep, headaches, severe mental pain, depression, anxiety, and worryation. And if you're wondering, no, worryation is not a word. Johnson was also now arguing in the amended complaints that PlainSite was a credit bureau regulated by the laws that apply to Equifax, TransUnion, and Experian, which assemble credit profiles on consumers. Johnson said that he was a consumer and his PlainSite profile, which contained information on him older than 7 years, was therefore unlawful. This was a tricky area because even though PlainSite was not a credit bureau, Johnson was probably clever enough to fool a judge into thinking it might be. Paul and Oliver looked over the amended complaints and more or less shrugged. Amendments were part of litigation, but we would definitely have to raise the issue of which complaint was the active one, and since we wanted to be in federal court, our clear answer was that it was the one that asked for $75,000, the first amended complaint, or FAC. Finally, there was the question of whether I should even be on the call. I wasn't planning to say anything, which would probably only cause trouble if I did. But I did want to be aware of what was going on. There was no telling how long the court would take to make a recording available, and I didn't trust anyone's summary since important details often get ignored. The lawyers were understandably nervous about my being present because given Johnson's aggressive posture, they were afraid the judge might call on me like a high school student during a pop quiz to answer questions about Johnson's allegations. I thought the probability was low, and to me, the risks of my being uninformed outweighed the risks of being put under a spotlight. I told them I would be on the call. Finally, it was October 20th, and Joe Johnson filed another motion. This time, it was to strike the amended notice of removal and to remand, the opposite of removal, which meant sending the case back to state court. He wrote, quote, here, the amended notice of removal is merely an improper attempt to create jurisdiction, not clarify it, to salvage an improvident removal by substituting itself as the removing party so as to create standing and federal removal jurisdiction retroactively. This is improper. The amended removal notice fails and remand under Section 1447C is required. He also argued that the case could not have been removed to federal court because when the amended notice of removal was filed, quote, no case was pending in state court at the time. This was getting irritating. He was trying to have cases proceed in two courts at once, while also arguing that the case had disappeared into a black hole and wasn't proceeding anywhere at all. And of course, all of these arguments had shown up the morning of the hearing, so that there was no time to process them. I dialed the court's conference call number and put my phone on mute. The courtroom clerk started out by calling the case, reading out the case number in yet another scrambled form, with the judge's initials first rather than last. Then Johnson and Think's lawyers introduced themselves.
The matter now pending before this court is civil action number TDC-22-2422, Joe Johnson versus Think Computer Corporation. We are here today for the purpose of a case management conference. Mr. Johnson and counsel, please identify yourselves for the record.
Good morning, this is Joe Johnson, plaintiff in the case.
Good morning.
Good morning, Your Honor. This is Oliver Edwards, counsel for Think Computer Corporation.
And this is Paul Allen Levy, also counsel for Think Computer Corporation.
Okay, good morning. So we're here for a case management conference in, I think technically is it 22-24-22, and it's the same players in 22-25-73, correct?
That's correct.
Yes, Your Honor.
Okay.
The conference started out with the most boring details. Whether we would agree to mediation. Definitely not. Whether we would agree to a magistrate judge instead of a district judge. Paul thought it was best to keep an Article 3 judge on the case, meaning one who had gone through all of the proper approvals by Congress as outlined in Article 3 of the Constitution. Then we got to the issue of there being two cases about the exact same thing. And that's when Judge Chuang started to show his irritation.
So so I can clarify what's happened here, is we had a state case that was removed in 2422, and Mr. Johnson wants to move to remand that. And then there was another removal of the amended complaint, but I believe it was in the same state case, correct? It just our docketing gave it a new number. Is that correct?
That is correct, Judge.
Sorry,
Levy, we filed an amended notice of removal in the existing case, the 2422 case, and then filed a new removal when Johnson objected procedurally to the existence of an amendment to try to simplify matters. Obviously, it hasn't simplified anything at all.
At this point, the judge agreed to consolidate the two cases into one, and Joe Johnson said he didn't have a problem with it.
I did not have any problem with that.
What concerns me is that the plaintiff, I think, is going to continue to argue, not only in this court, but in the Court of Appeals, about the procedural impropriety of an amendment. And the only thing that worries me is that if, when this case goes to the Fourth Circuit, which obviously we can't go up to the Fourth Circuit if there's a remand, but if you keep the case could go to the Fourth Circuit. The Fourth Circuit's going to have to wrestle with the same procedural issues that the plaintiff has raised, and it just makes me nervous that we don't have both the amended notice and the new removal still in the case. And for that reason, I think consolidation is probably, from Think Computer Corporation's, the safer track. But, Your Honor, will do what Your Honor thinks is appropriate.
Paul didn't actually say it outright, but what he was trying to signal to Judge Chuang here was that Joe Johnson was a vexatious litigant, that he wouldn't allow things to simply stand with this notice of removal issue, and that he'd probably file a frivolous appeal. The judge didn't get it.
Well, I don't understand what you're saying. I don't understand what you're saying, because the amended notice of removal was docketed in 22, correct?
That's correct.
But that's an amended notice of removal from the. What was the difference between the original notice of removal and the amended notice of removal? Just quickly, what's the main difference?
The difference is that Greenspan filed the original notice of removal, and not being a lawyer, he was not able to file on behalf of the company. And so what the amended notice of removal did was be filed by an attorney who's entitled to file on behalf of the company.
Right, okay, but it was 5 days later, so it's not really untimely, or there's no argument it's untimely, correct?
I think there's no argument that it was untimely.
But then what was filed in 2573 that is different?
Here, Judge Chuang took some time just to try to figure out what was actually going on.
Okay, well, we'll see. I mean, again, to me, it's just the height of absurdity to say we have two cases here.
The height of absurdity. He wasn't wrong at all. It was absurd. But it was an absurdity that Johnson had more or less forced on the court because he insisted on pushing forward with such an absurd argument that the amended notice of removal with a lawyer's signature wasn't good enough. The judge turned to the motion to remand, whether the case should be sent back to state court. Maybe it was because of Paul's tone. As you'll hear, he says his name so forcefully for the benefit of the court reporter, with a tone that could have been mistaken for annoyance, that the judge mistakenly thinks he's mispronounced it and apologizes. But for whatever reason, this is where things very quickly went off the rails.
Well, I guess, the defendant would take the view that the second amended complaint, well, the amended complaint really shouldn't even have been here anyways, because the case was sitting in the federal court, or the second amended complaint. Is that correct?
Both for that reason and because of a unique Maryland procedural reason that we don't need to discuss this morning.
Well, I'm not sure. Well, we'll see. But I guess let me start with this. I don't see where in here it says, as is asserted in the amended notice of removal, that the plaintiff seeks $100,000 or more in damages. And maybe I'm missing something, Mr. Levy, but could you just point me to that language in the original complaint where it states that the plaintiff is seeking more than $100,000?
Levy.
Levy, I'm
The
sorry.
original complaint seeks $25,000 for compensatory damages, plus general damages, plus punitive damages, plus an award of attorney fees. And when you and the amounts of general damages and punitive damages and attorney fees are unspecified. Now, for the attorney fees, so long as Mr. Johnson is pro se, he can't get any attorney
There's
fees.
nothing there. I agree with that.
Right, but we don't know whether he will remain pro se, at least in theory. As for the general damages and punitive damages, it's not at all unusual for punitive damages to be 2 or 3 times the amount of compensatory damages. So the way we got to $100,000 was by estimating punitive damages plus general damages as representing 3 times the compensatory damages.
Okay, that's fine, although I think those are pretty dubious theories, but I've seen them asserted before. But as I'm reading paragraph 8 of the amended notice of removal, it doesn't say we're estimating based on these other categories. It specifically asserts, as set forth in the circuit court complaint, plaintiff seeks $100,000 or more in damages. And to me, that's a false statement. That's a totally misleading false statement. So I don't understand how you go from that to now say, well, it's an estimate based on these categories. So why is that not I'm just somewhat outraged by that statement, because I look at this and I'm looking hard for the $100,000 and I'm not finding it in the notice of removal, in the complaint, or in the amended complaint for that matter. And so I'm just beside myself with that assertion, to be honest. I mean, to me, that's a Rule 11 issue. But you're saying that is, so you acknowledge there's no $100,000 reference in the original complaint or the amended complaint.
This was very bad. We had started off this hearing confident that the judge would probably understand that this was a vexatious litigant filing a bogus lawsuit. And now we had a judge who said he was somewhat outraged by what he supposedly viewed as a misleading false statement that left him beside himself because apparently he couldn't handle basic arithmetic. I was shocked. Paul and I had our moments of intense friction, no doubt, but Paul had done absolutely nothing wrong here. I had reviewed the amended notice of removal, and based on dozens of other similar documents I had also read, it looked totally fine. Lawyers made these calculations all the time. Moreover, Paul had even included a document from the United States Department of Justice's Bureau of Justice Statistics, hardly a questionable source from a court standpoint, along with the amended notice of removal, which spelled out that an assumption of punitive damages being worth 3 times compensatory damages in Maryland was entirely reasonable. But Judge Chuang wasn't having any of it. He could not handle the idea of addition and multiplication turning one number into another. And he had said the words Rule 11, playing right into Johnson's hands. I was totally stunned. All I could do was listen as the train wreck unfolded before me.
The original complaint does not use the number $100,000.
But
however,
you asserted to the court that he seeks $100,000, and you didn't say this is an estimate or an approximation, or we're going to use a legal theory under which, even though they don't give us a number, we're going to come up with one on our own. You just said plaintiff seeks $100,000 as set forth in the circuit court complaint, correct?
Now, what Judge Chuang just said is actually not correct. The actual text of that portion of the amended notice of removal says, quote, as set forth in the circuit court complaint, plaintiff seeks $100,000 or more in damages. In that, he pleads claims for $25,000 in compensatory damages, plus general and special damages, punitive damages, and attorney fees in his claim against defendant. Consequently, the amount of controversy in the circuit court complaint exceeds the sum of $75,000, exclusive of interest and costs. So it does lay out that it's not a verbatim quote, and why. And in addition, paragraph 5 above that says, quote, the complaint alleged compensatory damages of $25,000 plus general, special, and punitive damages, as well as costs and reasonable attorney fees. The judge knew all of this, so it's not clear to me why he decided to act as though none of those words were on the page. But he did, and his fury intimidated Paul into agreement.
Your Honor is accurately quoting the notice of removal. However, I think a fair construction of the notice of removal is that what we were doing was reading the $25,000 plus, and accurately saying that, in effect, this complaint seeks, as set forth in the complaint, $100,000 or more. I hear the court's reprimand.
We can agree to disagree on whether that's a false statement or not, to be honest, but I think we're disagreeing on that. Okay, so the first thing we'll do is the remand. I guess the point is, do you have any legal authority for the notion that, again, you just said there's no attorney's fees here because he's pro se. Mr. Johnson, just in looking at this, I can tell from your motion in response that you are not agreeing with this theory that there's more than $75,000 here. However, there are some scenarios under which, I guess the reality is if you are saying that your complaint, and it's a pro se complaint, and you construe those, liberally in various fashions, but when one construes that complaint, I don't see $75,000 here. However, what it also means is you're constrained by, not seeking $75,000. And so, and the case law is pretty clear, particularly if a plaintiff says, look, I'm limiting myself to whatever dollar amount, whether it's $74,999 or something like that. That's not a case that can stay in this court. But at the same time, if you were to seek more than that, whether in state court, on remand, or what have you, then they can bring the case right back. So that's usually a waste of time. So are you, as a practical matter, are you seeking more than $75,000 in total on everything?
Judge, it's Joe Johnson, plaintiff. No, Judge, I'm not seeking anywhere near $75,000. I think when I filed the original complaint in the district court is where it originated, and then was, of course, transferred to the circuit court. I was only seeking $25,000, and that was for all of the claims that was alleged in the complaint. And that's my position today. I'm not seeking anywhere near $75,000 on these claims.
This was obviously a lie. Johnson's first amended complaint literally said he wanted $75,000. Fortunately, Judge Twong picked up on that.
But then in your amended complaint, which you filed, which now appears in case 222573, I believe you now have changed the number to not exceeding 70,000, although, and maybe it's not clear from the wording whether that includes all of your compensatory, punitive, general, special, and statutory damages, or whether any of that could be above 70. But that is a lot closer to 75. So when you say you're no longer seeking, you're not seeking anywhere close to 75, are you seeking 70?
Well, when I was speaking earlier, Judge, I was speaking of the original complaint. The amended complaint added additional claims, different causes of actions based on events that occurred after the filing of the original complaint. So the closest, the third amended complaint that was filed seeks no more than the $70,000 in damages.
Inclusive of everything, meaning
that includes everything. That's
okay.
That's the cap for the damages.
Okay, I understand. So I mean that's how I read it as well. But I've had cases where plaintiffs say they were limiting themselves to 70, or in situations like this where there's perhaps some ambiguity, they make that clarification, and then they go back to state court, and then all of a sudden they're asking for 80 or 100, and then it gets removed again, and it's a little bit of a waste of time when we do that. So that's what I wanted to get clarification on. Okay. So am I correct, Mr. Levy, that your theory on removal is, leaving aside the issue about the attorney, which you acknowledge was an error, but you fixed it by doing the amended notice. The argument is diversity jurisdiction, correct? There's no federal question argument, is there?
Yes, diversity jurisdiction. And I would point out that in addition to seeking damages, the second amended complaint seeks injunctive relief. And Fourth Circuit law is pretty clear that you look at either the value to the plaintiff or the value to the defendant of the injunctive relief that's being sought. And I think a very strong argument can be made that the injunctive relief being sought in the second amended complaint is worth more than $5,000. And I can cite a case to Your Honor either now or in a brief if that is appropriate.
Well, I guess you're just going to have to brief this issue since you're obviously not getting the message on this. So, okay.
Judge Chuang's irritation with Paul, a lawyer who I thought was generally well known and respected, practically reached through the phone, but it sounded like maybe we were done. And yet, Joe Johnson still wanted to talk about his pointless sanctions motion.
Is there anything else we should discuss while we're here today?
Judge, I think that's it. Other than I think there was a request for possibly filing of a motion for sanctions. I don't know if the court wants to have that addressed or not.
After hearing Paul explain why the motion was basically moot, Judge Chuang decided to deal with it later, and after 33 grueling minutes, the hearing was over.
Well, with that, thank you very much, and we'll look forward to getting the briefs on the motion to remand. Thank you.
Thank you, Judge.
Your Honor.
Thank you.
At the end of the hearing, what had been decided was that the motion to remand would move forward, the motion to dismiss would only be an issue if the case remained in federal court, and the motion for sanctions would be tied to the motion to dismiss. The motions to strike the notice of removal and the amended notice of removal seemed like they probably weren't going anywhere. For now, we had to write the opposition brief in response to Johnson's motion to remand, and then all we could do was wait. And wait we did, for 7 months, from November 2022, when we filed the opposition brief, until the last day of May 2023. And you probably think I'm messing with you now because having a federal judge threaten Rule 11 sanctions against you for no reason when you're up against a vexatious litigant is pretty bad. And then, waiting on pins and needles for 7 months as you worry about the clarity of third-grade arithmetic isn't great either. But when I say it got worse, I'm not kidding. It got much worse, because this is the kind of thing our courts do. This nonsensical squabbling over everything but the substance of an issue, the notices of notices, the moral hazard of hourly billing that incentivizes baking inefficiency into everything, this is the law, and the law wasn't done yet. Broken is produced by Think Press and PlainSite, which are both brought to you by Think Computer Corporation. With the exception of court audio, everything you hear or see on this podcast, the script, the sound design, the mixing, the graphic design, the music, the website, and the Dolly image prompting, that's my doing. Until next time, I'm Aaron Greenspan.